If you own a property and have a second mortgage on it, and if you want to keep this property and get rid of the second loan, attorney Shah Peerally can help. Call 510-742-5887. Due to the uncertain economy, many people have settled their debts for a fraction of its value. It's recommended to use an experienced lawyer to deal with it. Shah Peerally is an experienced debt settlement attorney and has handled hundreds of such cases successfully. There are no upfront fees for debt settlement. Only when you win, you pay. Call Shah Peerally, attorney at law, at 510-742-5887 or visit yourdebtsettlementattorney.com for a free assessment. This is just an advertisement. No attorney-client relationship is established by this ad. The law does not guarantee success. Call 510-742-5887.
And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shah Peerally for the Shah Peerally Law Show, coming at you with over 50,000 watts of power. The Shah Peerally Law Show, where all your views matter.
Hello everybody. Assalamu alaikum, Sastikar, namaskar to all the listeners. This is attorney Shah Peerally for the Shah Peerally Law Show, and today we are the March 1st, which basically is the beginning of the month, exactly the beginning of the month, and a lot of things are happening. Number one, the big thing is the Supreme Court case, which is confusing everybody because it's pretty much is one of those bad decisions that comes from the Supreme Court once in a while. And one of them is basically holding people indefinitely when they committed certain crimes. And that's the part which is scary because they're going to use that against people, and they end up by holding people. A lot of people are arguing on that, say, hey, it's not that bad, etc. But I think it's bad because you cannot really deny a bond hearing. It's almost like Guantanamo now. So anything I'm telling you today, like I said, is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Feel free to reach out to us if you have questions, 510-742-5887. We will be opening the line, 408-912-5565, 408-912-5565. And as I was mentioning, this decision from the Supreme Court is not really great, and it's scaring a lot of people because if they pick you up, they can pretty much not deny you a bond hearing. A bond hearing is when they can release you. But a lot of people are saying, no, that's what not is meant. I didn't read the whole decision, unfortunately. I've been so busy, but from what I'm getting is that it's only for people who have committed certain kind of felonies, etc. But lately, if you see all the raids happening in California, especially in the Bay Area, etc., etc., we never know what is coming next. So people are very scared. It's a climate of fear, and we tell people to hang in there. And now they're upset at the mayor, I think, of San Francisco for basically tipping everybody that they will be coming. So in the meantime, ladies and gentlemen, we recommend that if you have any issues or if you're an employer, check on your employee's status and things like that. So it's very important. Now, the second thing that we have seen also is that the Supreme Court refused to review the DACA. They're very smart. They don't want to review the DACA situation. That means so far the lower court will prevail, which basically is blocking the Trump administration from removing DACA, which is some good news for some people, so good luck to all of them. Now, the other thing that we are seeing, which is very, very constant right now, is the problem that we are having with a specialty occupation. A lot of people are just getting denied on a specialty occupation in a very funny way. I'll give some examples. Number one, people are filing above level 2 and program analysts are getting denied still. We said that before because program analyst now is no longer considered a specialty occupation. We were thinking people who put it above level 2 will be okay, but they're still getting problems. Another situations we're seeing on specialty occupations is the fact that people are getting denied for no reason. Not no reason, but they're making a reason. And what they're doing is that they're just denying people really kind of almost arbitrarily, quote unquote, and then they're hoping that those people uh, will, um, will not really kind of go and appeal it. So unfortunately, we cannot really kind of get an exact answer. We have some people also who have an approval of the 797. When they go for stamping, they are getting a denial there. They're taking away the H-1B almost at the U.S. Embassy, stating that it's not a specialty occupation. It's almost they are as if they are reconsidering the whole thing. And these are kind of, unfortunately, things that are happening basically behind the scenes, blocking a lot of people. Another thing that we are seeing also, they're calling the end client to check on the case, because a lot of people, what they do, they will, for example, let's say you're getting a job and your employer puts you as a software engineer or something like that. And then the truth is that when they call the end client, they get the job description, they match it. It doesn't match a software engineer, it matches something else. They're coming back to the people and saying, hey, hold on a second, it's not what your end client said. So we are seeing all those scenarios. And again, ladies and gentlemen, if you have any questions, feel free to reach out. The number to the studio today is 408-912-5565. This is Attorney Shah Peerally, and we're live today on KLOK 1170 AM. And of course, we're discussing about immigration law, and we will be discussing about debt settlement. Again, the phone number for the studio today is 408-912-5565, 408-912-5565. Like I said, a lot of things happening where we are really kind of getting. It's very upsetting what's happening, because it seems like even the Supreme Court, which always comes with the reason, is although a lot of people are defending, I still defend the Supreme Court, but I still think that decision was wrong, and we want to find out if ultimately the war is not lost. It's still there are more battles coming, but it is kind of discouraging. And also, if you look what is happening on the sanctuary cities, where they are attacking the sanctuary cities, it's very, very scary. So a lot of things are scary. Having said that, we also have good news. We are seeing a lot of approvals. I'm not saying that, and people are frustrated. Sometimes they say, "Oh, their lawyers are the one messing up." But the truth is that some people are really doing wrong stuff, and they're ending up by the one coming and getting seeing unfair situations. So it is not really a matter of kind of what is happening, is how things are happening in certain places that is kind of worrisome. So I recommend that if you need help on an immigration case, please give us a call at 510-742-5887. And if you want to call the studio today, the line is 408-912-5565, 408-912-5565, and I have my good friend Franco with me today. And I don't know if I mentioned that earlier, but thank you, Franco, for being here. And we are really in the month of H-1B season right now. So H-1B is a priority and the main thing that we are looking at. So we're going to talk a little bit about H-1B on different issues and what we are seeing as things that you will want to know. Number one, we are seeing all those denials on the specialty occupation. For one, people are seeing themselves with cases where they feel like, okay, hold on a second, how am I getting denied? After so many years I've been living in the U.S. and I have been getting an approval. Now how suddenly I am getting a denial? So, and that's kind of the scary part, because so the biggest problem that I see in here is the thing is that people are not really ready when it comes to these cases. So no matter what they are doing, they are seeing themselves trapped into situations, and because of that, they actually kind of using that to the point that they are trying to hurt people some way, or somehow they are really kind of getting hurt. I mean, they're not hurting people, but they're getting hurt. People are getting hurt, and they are really kind of upset because they don't know which directions to go. Because if they go in a certain positions, the salary is too high, and the employer doesn't want to hire at that salary. And if they go in a different position, they're just getting a denial. And that's basically the catch. That's how they pretty much kind of been able to apply the H-1B rules without having to change the law. So what they have done, they have pretty much kind of made most of those specialty, those positions which are low salary. When I say low, it's not that low, but they consider it as low for H-1B. They're considering those as non-specialty occupation. And if an occupation is not non-specialty occupation, that means you don't get an H-1B. And that's where we are going. And again, it's the H-1B season right now, full-blown, and we are really kind of getting a lot of cases, but a lot of them are very much worried how this is going to happen or not happen. So if you need help with your H-1B, please give us a call, 510-742-5887. And if in case you're having issues with the line, just please give us a call. The number to the studio, if I'm getting it right, Franco, 408-912-5565, 408-912-5565. So we're going to take a quick break, Franco, and then we'll be back after those messages, and we will be talking a little bit about H-1B, more about H-1B, what's happening out there and what we are seeing and what needs to be do's and don'ts. So since I'm having an opportunity today to talk, we're not having that many callers, so I'm going to go over all the issues, not all, but at least many issues related to H-1B. So don't go anywhere, hang in there. We'll be back after those messages.
Beerables Inc. is an e-solutions company that provides custom web design, web application development, and internet marketing services to individuals and businesses. They can build powerful e-commerce sites, mobile apps, develop content, and market you on social media. They can help manage your brand's reputation and provide rock-solid customer support. Call today at 1-800-651-6091 or email us at info@beerables.com for a free consultation today. Again, the number is 1-800-651-6091.
And ladies and gentlemen, we're back after those messages. We have, I think, one caller. Let me take the caller, Franco. This is Shah Peerally. You're live on air. Hello? Hello? Okay, I'm really sorry, ladies and gentlemen. I think we are having some issues, definitely on technical issues on our side, so I apologize. So I'll try my best. I hope you're hearing me properly. I know the weather is very gloomy. We're seeing snow. We're seeing weird things happening around the world, and we really have to pray that it seems it's kind of weird and kind of sad that we are seeing so many things happening, especially with climate change. I know some people don't believe in that, and but I do, so it might be that. Let me take one caller. This is Shah Peerally. You're live in here.
Yeah, hi. I just had one comment on the this H-1B thing. Actually, I support the USCIS and the administration in the this H-1B crackdown, because these, especially the small consulting companies, had abused the system to such an extent that they were generating fake pay stubs for people who did not have projects, and they were paying very low salaries, and they were really exploiting their workers. And even the big companies like the TCS and Wipro, and they were doing a lot of malpractices. So I support that the H-1B crackdown. So just I had that one comment on this thing.
Sure. Well, definitely, the caller has a very good point. It's true, there are some abuses, but the truth is that it's not that like what they are portraying out there. It's just like since we want to get into the debate, it's really kind of a two-side debate, right? Number one is we have the people who believe that H-1Bs are exploiting other people's jobs. But that's not really true. There is a demand for it. But at the same time, there are companies that are taking advantage of people. That there's no question about it. The same thing with guns. So we can go on and on. The administration support guns when so many people are getting killed on a daily basis, and they are pretending, no, it's not happening. It's just like they pick and choose who they want to. Same for terrorism, right? They have one or two cases, but it's big. But every day, just like you have a kid going to school and killing 19 people, and that's normal. That's the kind of things that happens. It's very hypocritical to just say, oh, this is the system is definitely is not perfect, but the system has been set. H1B has been here for 60 years. So without H1B, America, we have to say the truth. Most of those big hotshot companies are owners or people who are basically managing those big companies came on H1Bs. You can look at the big ones. I don't want to name them, but they're really big. So, but of course, we don't support people who are taking advantage of people. It's almost like slavery.
Yeah, actually, the genuine H1B people, they will have the salaries that meet the H1B requirements, and only the consulting companies, and the big outsourcing joints, they are the ones that will not be paying the H1B what he should be paid. So the law that they are trying to enforce, that makes sense. Because if you are in a real H1B, as you said, the deserving people, they will have high salaries.
The problem is that
the
problem they are not doing it because of that. That's the problem. They are not. The goal that people are genuinely thinking, okay, we're picking the one that we need. No, they are just picking whoever they want, and they are pretty much going. If you look, it's pretty much based on the color of the skin, unfortunately. That's what is causing all the problems, and people are getting irritated. And it's not, I support the administration when it comes to fraud, but I don't support them when they pretty much pick and choose who they want to immigrate. For example, you have Trump saying, hey, we want people from Norway to come here. They're not going to come here. Why they will come here? Their life is better off there. So it's not, we cannot really say that's the truth. But at the same time, yes, I agree with you. There are abuses, and that we have to control. But there are ways to do it without putting people in fear. And I'm telling you, I work with a lot of pretty medium companies or startups, and those are not consulting, and they're still getting problems. So the problem is that because of one group of bad people, other good people are suffering. I agree with you.
That's
definitely.
True, yes.
Okay, thank you so much for expressing that. It's a very good thing you said that, because the debate is important. And I know people who take advantage of it, and I don't like those people either. Okay, good luck to you. Take care. Let me take another caller. This is Shah Peerally. You're live in here. Hello? 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 Okay, so I lost the other caller. Do we have someone else? This is Shah Peerally. You're live in here.
Hey, good morning. My name is Kumar.
Hi, Kumar.
I have a question. I have a quick question on the EB1 category. So I have a situation like my V2 was filed in 2012 with some other employer. I have one I-40 approved. Now my current company is going for a EB1. I'm eligible for EB1. Should I port my I-140 with current the new EB1?
No,
is it eligible?
Because EB1 is a current date, so you don't need to port any date. Because EB1 is already current. You can port it if in case EB1 gets retrogressed. You can even do that at a later stage. You don't have to port any dates. Because EB1, even for India, is current, so you can just use that.
Oh, okay. So I don't have to do anything. Just go ahead with the new application.
And then let's say God forbid EB1 goes backward, you need to port it. You can still do that at the I-485 stage or at the I-140 stage. So you're fine. Okay?
Oh, okay, perfect. Thank you very much.
Okay, good luck to you. Good luck. Let me see if we have more callers. This is Shah Peerally. You're live in here.
Hi, I have a question about naturalization, and basically I'm on green card, and I wanted to ask that when you file for the citizenship, is there any restriction on leaving the country?
Yes and no. The restriction is if you leave, let's say for example you file the case and you leave for more than 90 days, when you go for the interview, they might make a fuss about your kind of your jurisdiction, because they might say, oh, you're not living here anymore. But apart from that, no, there's no big restriction. But I don't recommend people to travel in between. But if they travel, don't travel more than that's like 2 months. Don't even reach.
Just a few weeks or something, maybe a week or two.
That's fine. That's fine. But just make sure someone can take care, because you never know, you might get an interview if you're lucky or unlucky. I don't know. So just make sure someone picks up your mail. That's all. Okay.
Okay. All right. Sounds good. Thanks.
Good luck to you. Let me take another caller, Franco. This is Shah Peerally. You're live in here.
Hi, Shah. Thanks for taking my call. I am a recent U.S. citizen. I'm planning on applying for a green card for my mother when she visits us in May. So she doesn't have a birth certificate, so we are currently working on getting a non-availability certificate for her. Now, as I understand, once a visitor comes into U.S., they cannot immediately apply for green card. There has to be some waiting time, like 90 days, before they can apply for green card. All right?
Yes. Yeah, and that rule is basically based on preconceived opinion. So if you already, the way the rule works, if you already have in mind to file a green card and you make someone enter on a visitor visa, there is a presumption you committed fraud on the visitor visa. So most of the time, let's say for example that person enters and then you decide to file the green card, you're fine. But if you're already preparing everything and if at the airport they find out, they have a right not only to deny your mother entry, but they can also put a bar on her. So you need to be careful how you do that.
So my question was, if you get the non-availability now, it will show an earlier date than the date of travel. So will that be a problem? Will that be considered as, because they're getting the non-availability for submitting for green card, will that be a problem?
Yes. It can, because what is the problem is that now with the Trump administration, it used not to be a problem. The Trump administration, they're looking at the intent issue. So the intent issue is very clear. If they come back and say, hey, you already planned this, they will not attack the green card. They will attack the fact that you entered on the B1. So it is tricky. I would recommend you talk to a lawyer before you do anything. Give me a call at the office. We can talk in private. 510-742-5887. Then we can talk, okay? Okay?
Okay. All right. Thank you.
Good luck to you. Good luck. Let me take another caller, Franco. This is Shah Peerally. You're live in here. Hello?
Hi, sir. How are you?
I'm doing well, sir. How about yourself?
Yeah. I'm fine. Thank you. So I have my I-140 is approved under company A. Last year only I changed my employer to company B, and I got the H-1B approval for 1 year. Now I have my H-1B is under extension process. But I think my attorney is saying that it is not good to go for the premium processing, so I'm going for regular processing. But my H-1B is going to expire in March after say 10 days. So, what kind of action plan is available for me, or options available for me?
Well, you can go ahead and file it, because as long as it's pending, you're safe, right? The problem will be if you have up to 240 days, kind of, to continue working until you get an answer. But once you reach that 200 days, I recommend that you go ahead and you pretty much kind of file a premium if you don't get an answer. But yes, when people are filing under premium, they are getting an fee. That's pretty much becoming almost like a given. But sometimes it's good to do it. But as long as the case is pending, you will be in what we call a period of stay authorized by the Attorney General, kind of. It's a period of stay authorized. It might not have the word Attorney General on this one, but what it does, it pretty much keeps you legal. And as long as you don't pass 240 days, you can continue working. But ultimately, if you're not getting an answer, you reach around 200 days, I recommend you call the USCIS or you file under premium, then you upgrade it. But you will be safe as long as pending. But the problem is that all this time you won't be able to travel, etc. So be careful on that, okay?
Understood. I was just thinking, can I apply for the April quota?
Why do you want to apply for the April quota? You're filing an extension, right?
Yeah. My extension is processed. Can I go for the new H-1B process?
No. You cannot.
Okay.
Because you don't need it either. How many years you use your H-1B?
I have completed 10 years.
10 years. Okay, then. Yeah. But you have an I-140 approved, right?
I-140 is approved. That's it.
Yeah, but there's no purpose to go for the new. It doesn't make any sense. You don't need that.
Oh.
Okay.
Oh, okay.
Okay.
Thank you, sir.
Okay. Good luck to you. Let me take another caller, Franco. This is Shah Peerally. You're live on air.
Yes, hey Shah, this is Sumit. I had a quick question. So my wife is under H1B. Her extension is due, and she is working as a CPA. Do you think, so the company filed for normal H1B. We are thinking to make it premium processing. Do you think that's a good idea, or should we just let it continue?
It depends on the situation, right? In your case, you don't really need the premium, then don't use the premium. The reason you do the premium is that if you don't feel secure or you have to move to another company after that, then it's a good idea. But apart from that, most people are not filing premium right now because they are worried about the RFEs, and the RFEs are hitting. Actually, RFEs are hitting really weird ways now. I had a client today where well, not my client, but someone I spoke to. He told me that he contacted the USCIS to correct his name because they made a mistake. And guess what? When he corrected, they sent him a long RFE asking him about a specialty occupation, and that case was already approved. So, unfortunately, right now, the way things are going with USCIS, any chance they get to deny you, they will deny you. So, I am advising people to do premium only if it is necessary. In your case, since it's not necessary, then go in the normal way. But make sure if you don't get an answer within 200 days, then you upgrade to premium, okay?
Okay, makes sense.
Okay. So, let me take another caller. This is Shah Peerally. You'll have an ear.
Hi, Shah. I have a question.
Yes.
I'm on H1B with the employer A, and it is approved till next year, 2019 December. And I'm planning to go to Mexico in this year June for about 2 weeks. If I change the employer, if I change the job before that, what's the process? Do I have to go get it stamped in Mexico?
Let me get it right. I didn't get the question completely. I had some background noise. Can you just repeat what exactly you were saying to me?
Right. I'm on H1B, and it's stamped till 2019 December with the current employer. And if I change the job now to another employer, and if I travel to Mexico after that, right?
Okay. Yes.
Do I have to get it stamped again, or I can use the same stamp?
No. You can use it. No. The stamp. When you move company, the stamp is still good unless the stamp was revoked. You don't need to go get a stamp again. You just have to get your 797. So you don't need a new stamp. You're fine.
Oh, okay. Okay, perfect. Thank you.
Okay. Good luck to you. Let me take another caller. This is Shah Peerally. You're live on air. Hello. Okay. So, ladies and gentlemen, we got a lot of callers. It seems like the weather is causing the delay, and then everybody's calling at the same time. I really wanted to thank you for calling, and I wanted to thank Franco for being there with us. And today we had different opinions, and we had issues about premium processing, which is something big. Should you or should you not file premium processing? Depending on your case. If, for example, you're already out of status, you have to, basically then maybe file the premium so that you can leave the country and come back to get your I-94. Otherwise, it's not going to be possible. It is going to be really kind of difficult right now just to decide if premium or not. But I recommend premium only if it is necessary. Let me take another caller, Franco. This is Shah Peerally. You'll have an ear.
Hello.
Hello. Hi, this is Shah. You're live on air.
Hi, Shah. Good morning. So, I'm working in a consulting firm with a client, and then so they had to file. I'm on a STEM OPT, and they had to file my H1B this year. So what happened is, my client, I have a renewal after June. So they said they cannot give the renewal now, and my consulting firm is saying, until we get the renewal, until October at least this year, we cannot file the H1. But I'm saying, why can't you start filing the H1, and once we get the extension, we can put the papers to the USCIS. So will that work, or?
Well, the thing is just like without the, you mean the end client letter? That's what you're missing, right?
Yes. I mean, like, I have it only till May, and then it will get extended again somewhere in April. So.
Yeah,
and then
it will be tricky. It will be tricky because without this, you're going to have a problem. So basically, what you need that end client letter, but you can try to file it and then maybe add it later if there's an RFE. There are some tricks to do that, but it's a very difficult one. Maybe give me a call at the office. Let me analyze your case. I can tell you because there's no straight answer. But without the end client letter, especially there was a memo, by the way, I didn't mention that. I published that on my website. It's on peerallylaw.com or attorneyonair.com, where basically they're talking about exactly this situation of proving that you have an end client. If you don't have the letter, they won't be able to file it. If they file it, they can, but ultimately there will be an RFE. They will want that end client letter. And if you look at my website, you will see it's called USCIS Policy Memo Contract and Itineraries Requirements for H-1B involving third-party websites. So this memo is specifically addressed to your issue, and they kind of clearly say without that they won't pretty much kind of grant.
So I have the end client, but the point is like it's expiring in May, and then but
if you file an extension, then they will stop the extension up to May only. That's the problem. So it's not really.
So they'll file the extension until next May, right? If they do it, but it's that they can. The client is saying we cannot give the extension until beginning of May.
Well, when is your H-1B expiring?
No, I'm on a STEM OPT. It's my fresh H-1.
It's your first H1. You're moving from STEM OPT. Yeah, because the problem is that, how they can... Well, what they can do is, give me a call. I'll tell you some ideas. But one of the ideas is to file it with what they have, or file with no end client letter, and then there will be an RFE, and then they can insert the new letter by that time. But they need to make sure that you're going to be working with that client. Otherwise, you're going to be stuck. Okay?
Sure, but we can start, right? Because I have a client, and then I can update.
It all depends. It all depends. I cannot say yes because I might not have all the data in front of me, but probably yes, it is doable because ultimately you will get the letter. You can just insert it at a later stage, but you need to make sure that the address, everything, so that they do the LCA is confirmed, so that we don't have this problem. So
and then even in this case, we get an RFE, but we won't get a rejection, right? Straight away without checking for the details.
You can get a rejection. It's very hard to get a rejection, but there's a chance. But usually they will ask you to prove that basically you have an end client. By that time, hopefully, when the RFE comes, you will have the end client letter with you. Sure. But that becomes a little bit tricky. But it is doable. Give me a call and then we can talk in more details through a consultation if you want. 510-742-5887. Okay? Good luck to you.
For sure. Thank you.
Take care. Bye-bye. Let me take another caller. This is Shah Peerally. You're live on air.
Hey, Ali. This is Krishna.
Hi, Krishna.
So I have a question for you. Like, I have an approved 140 around 2 years back, and actually I'm planning to relocate to India for about 3-4 years. And my question is, can I come back on this 140 again later if I decide to, relocate here?
What do you mean come back on the I-140? The I-140 doesn't allow you to come back. Oh, the H-1B allows you to come back, but yes, the I-140, as long as it's not cancelled, you can still use it to extend your H-1B, yes. But you cannot use that. You can also use it to get a green card if you go back to work for that company. But ultimately, the I-140 is alive as long as they keep it alive.
Okay. I no need to. I'm not. Go for lottery again, right? I can.
No, you won't. You probably won't as long as you have the I-140. The only issue is, of course, if your I-1... How many years you used your H-1B?
Now until it's been 9 years. My 140 priority date is in 2014. It's in EB2.
Okay. Okay, so basically in this case is, well, you will be able to use that I-140 to get extension if you need to. So at this point, you will be able to use that. You can even use it to get a green card if you want to, if the company is still willing to take you. So yeah, to answer your question, yes, you can use that I-140 for H-1B. But the only thing that might cause a problem if the I-140 gets revoked by the USCIS for some kind of reason, which is rare, but they might. And if that's the case, then you won't be cap exempt anymore. Okay.
Oh, okay. Got
okay.
It.
Good luck to you.
Thank you.
Let me take another caller. This is Shah Peerally. You are live in here. Okay, so the number to the studio, we can take some few more callers, Franco, is 408-912-5565, 408-912-5565. The big news today is, of course, this decision from the U.S. Supreme Court that is scaring a lot of people. It's almost like indefinite holding of people without a bond. That means basically people getting arrested, people who committed a crime, and even they have an asylum file or something like that, they can still be picked and put in custody, and they don't have to get a hearing for a bond to be released until they reach the immigration court, which is another problem. And that's kind of scaring a lot of people. Having said that, many people are not, luckily in our listeners, most of people are not affected by that, but still there is a portion of fear that is coming out of it. The second thing I wanted to mention, of course, is before I take the other caller, is debt settlement. This is another thing that we handle a lot, and right now a lot of people are panicking because if in case they have to go back for some years and stay in their country, what happened to their debts, or if they have to go back suddenly, we can help you. We can get rid of those debts. The number is 510-742-5887. The blog to check is www.yourdebtsettlementattorney.com, yourdebtsettlementattorney.com, and I don't think you have to put www now. Let me take another caller, Franco. This is Shah Peerally. You're live in here.
Hey, Shah, this is Vinu. Can you hear me?
Yes, I can hear you, Vinu. Go ahead. Speak a little bit loud because you have a background noise. Go ahead.
Oh, okay. So I've recently applied for the amendment. So I'm working for a company A, and the company is moving me to Seattle from California. So I've applied, my lawyer applied amendment plus extension. So is it like, because my visa is approved until 2019, I asked them to just apply for the amendment, but they applied for the extension also. So does it affect the case, or and that they have applied in premium?
Well, technically, when they do the amendment, the extension is included in there. So it doesn't, whether you like it or not, they probably will include it. So it's not going to affect you, but depends what box they tick. Did they tick the box of amendment or the box of extension? So that's another issue, and that's going to be hard. It's not a big problem because what they're going to look at is still the rules of H-1B. Do you meet the minimum requirements of specialty occupation? Do you have, etc., and client, employee-employee relationship, etc.? But apart from that, no,
I work for a company which is like a direct product-based company, so I don't work on a third party, so it's a full-time employment. So,
so you should not have this problem.
Okay.
Yeah.
Okay.
So you should be fine. Okay. Good luck to you. Okay. Hello. Okay. So let me take another caller, Franco. This is Shah Peerally. You're live in here.
Sure. Thanks for your service. And this is Raj. My quick question will be, what is the significance of this policy of memorandum released on February 22nd? When I read through that, it looks like it's all already in effect, like employer-employee relationship. I mean, what about the content in that policy? Is there anything new that we should understand? I'm in H1 in EB2 and then doing extensions with I-140 approved. That's my
Yeah, you're exactly right. It's not new. What they're trying to do is basically putting the dot on the I, I would say. So basically what they're saying is that, hey, we are reminding you that you are supposed to do this and that and that, and we're going to enforce this really strictly. That's all that they mean. Pretty much everything which is in there has already been applied, pretty much like you said. But they are basically reminding people, hold on a second, we don't agree. And also they're basically, what they're saying is the same thing I've been saying. So you're basically guilty until proven innocent now. So that's all they're saying. So unfortunately, you just have to read it, and basically now they're just making sure that, hey, it's there. You guys know about it. Now they're going to start kind of using it more heavily. They're already using it heavily, but yeah, like you said, it's the same thing. They're just making sure that we know about it. It's like rubbing our nose in it. So, like, okay?
No problem. Yeah. So just want to confirm with you. Yeah. So I don't know whether it's from a layman point of view or a attorney point of view. Is there something significant that we should understand and then we should aware of? That's the reason I called it. Thank you.
No, the thing is just like it's the same thing. They're talking about the 2010 memo. They're talking about the employer-employee relationship. They're talking about the special occupation. I think I don't know if they support. And then they are talking about the supporting documents that you have to provide. And they're basically kind of taking all those rules and putting in one memo. It's more guidance for their own team to make sure that for those who basically were just approving cases before not letting certain things go, they want to make sure that, no, you don't approve it just like that. Make sure you have this and that and that and that. So it's more for their internal use.
One point I understand from that is when they specifically mentioned the third-party consulting firms. Is that something new?
A third-party consultation firm is something that we have been working with for ages because that's how consulting companies operate. They have layers, EVC, etc., etc. So basically what they're saying is that more you dilute it, more your chances of employer-employee relationship is reduced. So, for example, if you have A, B, and C, you are okay. But if you have A, B, C, D, E, F, G, you have to document how they are related. And A to B, B to C, C to D, D to E, and not only that, you also have to explain how not only how they are related, but how do you go back and control your employee when you have so many levels. So this is where they're cashing in a little bit because that has not really been an issue before. You could have 20,000 layers in between, kind of quote unquote. It's not affecting the case, but now what they're saying is that more you get layers in between, you're diluting the case. So that's what they're talking about. But at the end of the day, it's not like they're saying anything new, and that's how they have been very smart, by the way. They have been playing with the existing laws to basically cut off people using discretionary power. And that's what they've been doing with the specialty occupation. That's what they have been doing with the State Department. And now that's what they're doing with the H-1B. Whenever you see those kind of memos coming from the Trump administration, you know they're going to hit hard and really hard. So we need to be ready now. Whenever you have people having levels or different people in between, they need to be ready. But that memo is major, and I published that for those who don't know. It's on my website, attorneyonair.com.
Yeah, I mean, especially the media is like, portraying that it's a kind of a new memo or something from today onwards. That kind of an image is like, especially from Indian media.
Because this is a problem. It's like nobody has cared about it. For people who live it every day and people who work on it every day, we know about this. These are stuff that has been there, the 2010 memo, the 1995, you name it. All the stuff are existing stuff. All they did is basically telling you, hey, just to remind you, if you walk on this side of the street, we're going to punish you. That's all they're doing. And basically by doing this, now they're reminding their own people, hey, don't forget any of those when you check the cases. So basically it's more an internal thing, but at the same time it's also what we call a scare tactics. And they expect that they will be more strict. They're already very strict. They're going to get worse. That's what I'm saying here. But you're right. It's nothing new. I read it. I'm reading it right now again as we go. But I don't know, I missed something, people can tell me, but all the stuff we have been dealing with, right?
Exactly. So as a user, when I read that, I thought, okay, it's all, we are already doing it. So what's new in this? So that's how I feel. Okay, thanks for confirming. Thanks.
I'll tell you what is new. What is new is that you have a bunch of people trying to scare another bunch of people. That's all. Okay, that's all. But no, it's not new. Okay, good luck to you. So yeah, for those people who kind of join in right now, we're talking about this new memo that came out from the USCIS, which I publish on my website, attorneyonair.com. It basically is the memo we're referring to is contracts and itineraries requirements for H-1B petition involving third-party work sites, which basically they're talking about H-1B consulting companies. So read it. Like I said, it's nothing new, things that have been there, but they're just making sure people know about it, that's all. So let me take another caller, Franco, and I don't know how much time left. This is Shah Peerally, you're live in here. Hello?
Hello, sir. Thanks for taking my call.
You're welcome, sir. Go ahead.
I have a question on H1. I'm on H1 visa, and my 6th year is getting over in September. So I have to file for extension. I have 140 approved. And I work for a big consulting firm. So my question is, my client does not provide the client letter. And considering this new H1 memo last week, what will happen in that case wherein my client does not provide the client letter? Can I still file the extension and can I get it approved?
Okay. Still filing it, yes. Getting it approved is a different story. But having said that, I'm going to be honest with you. We have not seen any approval without the end client letter. However, what we used to do, we used to be able to prove that there was work, because if you look even at those memos that are referred in that appendix memorandum that they just issued, they're referring to the old one. All the 2010 Neufeld Memo, all it says is you have to prove there is a relationship and there's work for that person. And the truth is that also in that memo it says you don't have to actually have an end client letter. But now what they have said, the position they have taken is no, we want the client letter, and that memo doesn't really say that. There will be some fights on this, definitely. But ultimately, to make it easy on the people, everybody's going to just ask, hey, give us an end client letter, otherwise you're going to get in trouble. So it's just to let you know, I'm pretty sure, yes, if you don't have an end client letter, your chances of approval is almost maybe 5%, 10% now. That's all.
Oh, 10%?
Because
okay.
Because they made sure that they mention it, right? Doesn't mean you cannot get it, but there's a big chance they will deny it. Yes.
So, but my employer has a master service agreement with my client. Will that not be enough to prove that?
It might, but it's not. What they want to do is to prove that specifically you are going to be hired there. A master agreement, only thing it says is just a master agreement, which was working before. What we used to do is we put the master agreement and we put some emails or any kind of paper to prove there's a link. But now it seems that they're not going to accept that. You can still give it a shot because this memo came out, so we don't know how they're going to react because they're still going back. That memo is just going back to the old memo, so there's nothing new. So we are hoping that it will work. So just hang in there, try to file it, and then we'll see what happens. But from seeing that memo, they're doing something they're already doing, like the caller was saying, except now they're going to get a little bit more strict. So your lawyer will have to be smart. And I don't have an answer at this point until they start getting testing on the memo. But my take on it is that without the end client letter, you're going to have some issues. Okay.
One last quick question: in case H1 gets denied and 6 years are over, but I-140 is approved, then what is the option for us in that case?
Well, you can continue with that. Yeah, you can continue with the same company. Because the I-140 is approved. If the I-140 is not approved, then you have to go back or you have to move to another visa. No,
I-140 is approved, but 6 years are over and extension is rejected. then what
Yeah,
we
you
can
can.
do?
You can always refile it with another company which has an end client or which is a direct client, because as long as the I-140 is alive, which it will because of the new law, you can always transfer without any problem. So it's not
Even the
not a,
even the same employer can file another extension with different end
Yes.
clients.
Yes, yes. The only
Oh,
difference
wonderful.
is that if the dates, well, it's not very wonderful because there are other issues you have to deal with. But yeah, you can file, you can file it with another company too. You can file with another end client, etc. But make sure it's filed before the previous one gets expired. Otherwise, even you file it, you will have to leave the country and come back to get your I-94, and this is where the problem starts. So if you're having a problem like in your case, because I don't have much time, you give me a call at the office. We can look at it, and I'll tell you about maybe some other options. Okay?
Sure, sir. Thank you so much. I appreciate it.
510-742. You're welcome. Thank you so much for your kind words. The number is 510-742-5887. I think we have one more caller, Franco, right? This is Shah Peerally. You're live in here.
Good morning, Shah. I have a question. So I applied my H1B extension and H4 for my wife at the same time. I received the H1B approval, but H4 we didn't hear about. And we also received the H4 EAD also. So I'm wondering if we need to travel right now, what we should do.
Okay. Let me get it right. You filed the H1 and the H4 and H4 EAD for your wife. You got your approval because you filed in the premium, but you didn't get the approval of the H4. You said you got the approval of the EAD, or you didn't get it?
Yeah, we got H1B as well as H4 EAD.
Okay, you just didn't get the H4. That means the H4 was approved. It's not, they have not given the receipt, because the EAD will not be issued without the H4. As for traveling, I will not recommend traveling until you get that receipt in your hand. But if you travel, you come back, actually it's still okay. She just have to go and get a stamp and then come back. And then when she come back on her H4, she can just use her EAD. She'll be fine.
Yeah, but our stamping is expired, so we will not be able to come back, I guess.
Well, you have to go and get a stamping, yes. But you don't need that approval notice to go and get the stamping. You just need your approval notice. H4 doesn't work like H1. Okay? Okay.
Thank you.
Good luck to you. Let me take one last caller. This is Shah Peerally. You're live in here. Okay. So I think, Franco, we don't have much time there. And then since Amit didn't call, okay, let me take one more caller quickly. This is Shah Peerally. You're live in here. So I think, Franco, we don't have much time there. Hello? Hello,
hi.
Hi. Go ahead, you're live in here. We don't have much time.
So
Go
my
ahead.
question is that
You have to turn
I'm
off
going
your
to...
radio and the... Yeah. Yeah, go ahead. I won't be able to hear you because you have background noise. You have to turn off the radio. Let me take another caller. This is Shah Peerally. You're live in here. Okay, so ladies and gentlemen, I don't think I have much time now. I won't be able to take the callers. I have 2 minutes to go. So what I'll do, I just want to wrap up. We have all those nice discussions about the problems that we saw now in the decision of the Supreme Court. There was one good decision, one bad. The bad decision is that they pretty much can keep people almost indefinitely. And the good decision is that the DACA is not blocked somehow. But at the same time, we had this memo coming out, pretty much reiterating what we already doing, like the caller was saying. And all those things are happening simultaneously, and it's scary. Of course, it's scary. We are dealing with them. But at the same time, we are having good news. We are winning cases. We won a bunch of other cases, including we won so many on the front of EB1, national interest waivers. Even though you're seeing a lot of people getting denied on L1 and everything, our office is still doing well. And right now it's H1B season, so if you're a company or an employee, you want to file an H1B, feel free to call our office, 510-742-5887, the website to check, attorneyonair.com. And before I go, I wanted to mention a little bit about debt settlement, because this is becoming another issue where people are in debt, they are losing their jobs, or they have to leave the country for whatever reason. We can help you get rid of those debts. For example, you owe maybe $20,000, $50,000, $100,000 on a credit card. We might be able to settle it for less than the amount that you owe. And you can check that on yourdebtsettlementattorney.com, yourdebtsettlementattorney.com, and you can also check call our office 510-742-5887 if you need any help. And today I had Franco with me on the line, and before I close, I think I have a couple of more minutes. I wanted to tell people it's a very tough time right now, and we have those issues going on all over the country, and including the gun issues. No matter which side you are on, I'm not pro-gun definitely, but at the same time, I believe also in the Second Amendment. But that's not what the Second Amendment says, by the way. It doesn't say to just hold a machine gun with a kid, and we saw the drama, and it gets us scared parents to send our kids to school. So I know the kids are really standing up. It's the first time I really see the millennials standing up and really walking out, and they're going to do that on March 24th, and we support them, and we hope they're going to do well. And it's really good to see that the young people are taking the lead. And also, ladies and gentlemen, like I mentioned earlier on the show, if you need help with any immigration matter, whether it is employment-based, family-based, investor, EB1 especially, we are very good at the EB1. You can check some of our website, and the EB1 is EB1A, EB1B, we can help you. Just give us a call, 510-742-5887, 510-742-5887. And also to let you know that in this case, if you need any help with our from our office, don't hesitate to call or email us, info@peerallylaw.com. So again, website attorneyonair.com, and also if you need for debt settlement, yourdebtsettlementattorney.com, yourdebtsettlementattorney.com, 510-742-5887. Anything I told you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. And thank you, Franco. Take care. We'll be back next week. Bye-bye.